everyone. It's now 8 a.m., and I'm going to call this meeting to order. Just for the record, Madam Clerk, will you call the roll?
Mayor Urban.
Present.
Alderman Seville.
Present.
And Clerk Stallings is present.
All right, at this point, with the hearings concerning mayoral candidates, I will substitute myself out, and I believe Alderman Seville or Garza will be stepping in, taking my place for these particular hearings.
Thank you, Mayor. Okay, I am Alderman Juani Garza, the chairperson of this electoral board. Also on the board is Michael R. Seville, senior alderperson, and Jennifer Stelling, city clerk. The Illinois Election Code mandate a service to hear and pass objections filed against candidates' nominations papers on the city of Aurora. Roll call again?
Yeah.
Call roll? Okay. Alderman Mike Seville,
Present.
member. Member Stellings,
Present.
and myself, Substitute Chair Garza. We have a quorum. And this time, we are going to address the rules of procedures, and I'm going to briefly turn it over to our board attorney to explain the proposed rules of procedures.
Thank you, Madam Substitute Chair. My name is Ross Seckler, serving as the Electoral Board's attorney for these proceedings. The proposed rules of procedure, and there are copies on the dais for the public, as well as, and I have the official copies here for the board. These are versions of the rules of Electoral Board rules of procedure to establish fair and transparent hearings. They are based off of iterations of the Chicago Electoral Board and Cook County Officers Electoral Board and State Officers Electoral Board, which routinely and professionally do these types of hearings. These are also substantially similar, except for some dates and references to prior COVID remote proceedings, to prior iterations of the Aurora Municipal Officers Electoral Board Rules of Procedure. And so and they're quite standard for these types of proceedings. So I would request that the board move to approve the rules of procedure as presented.
So moved.
I move this electoral board adopt the rules of procedures as presented.
Second.
Okay. So now I will turn back over to our attorney to proceed through the remainder and the agenda.
I think you need to vote.
Yeah.
To vote on the
Okay.
rules.
Motion can made and second by the three electoral board members. So it's already motion by Jennifer Stillen, and I'm second.
Just a roll call vote.
A roll call again. Okay. Alderman Mike Seville,
Yes.
member Stellings,
Yes.
and myself. So yes. So it's 3-0.
If you mind,
We have quorum.
just exit.
Okay.
Thank you. And now, as board attorney, I'll help guide through the proceedings, and we'll start with the proceedings on the various objection cases that were filed. Again, as was previously noted, we'll start with the mayoral objections. Therefore, Alderperson Garza is sitting as substitute chair by statute. We'll first call the first case of Tara Loza versus Jasmine Garcia, which has been marked as case number 24-AMOEB-01. Are the parties present? And if they are, can you please approach? Yes. So for the council, this is Ross Seckler, and the others will announce before we speak.
Just the people talking on the sides.
Oh, perfect. Thank you.
Good morning, I'm John Fogarty on behalf of the objector.
Jasmine Garcia.
Thank you. Have you filed your appearances, or will you file your appearance?
I will file one right away. I'll send her one to Ms. Garcia.
Thank you. And Ms. Garcia, do you have an attorney, or are you planning to represent yourself in this matter?
Yes, representing myself.
Okay, thank you.
So can we take a 5-minute recess, Ross? I'm sorry I want to just talk to her about representation if she doesn't have an attorney.
That's okay.
Yeah, that's fine. Yeah. We'll stand in recess for 2 minutes.
All right. That's fine.
Okay.
Continue.
I'm going to file an appearance on behalf of the candidate. Her attorney was supposed to be here this morning, Mr. Morphew. He is not here, so I will represent her for purposes of this hearing.
Okay, that's fine.
No
Is-
objection.
Yeah. If you don't mind passing those, this is for the first case. And you'll, if you can, if by the rules, if you can, email me a copy of your appearances, and I'll distribute it as well to, and if Mr. Morphew wants to enter an appearance, he's free to email it in and join you as counsel.
Sure.
Yeah. So for the first order of business will be the introduction, labeling, and entry of the Electoral Board's exhibits. I would propose and ask for a motion for the Electoral Board to move to enter into exhibits the following exhibits as marked. Exhibit 1 would be the objector's petition filed in this case. Exhibit 2 would be the candidate's nomination papers. Exhibit 3 would be the call issued for this Electoral Board. Exhibit 4 would be the agenda posted for this initial hearing. Exhibit 5 would be any proofs of service, waivers of service, and appearances filed by the parties. Exhibit 6 will be the rules of procedure adopted by this Electoral Board that were just moved and entered. Can I please get a motion to accept the Electoral Board's exhibits into evidence?
So moved.
Second.
Second? Okay, motion by Stallings, second Alderman Mike Seville. All in favor, say aye.
Aye.
Okay?
So
Yes.
those will be, those exhibits will be entered as stated. The next would be the, if the objector or the objector's counsel, can you please provide a summary of the issues raised?
He's talking to you.
I'm sorry, I was listening to counsel.
Issues raised by your objection.
Yes,
Issues
yes.
briefly described without argument, the issues raised in your objection.
Yes, 2 issues on this candidate. First, there are not enough valid petition signatures. Secondly, an allegation that this objector has made against this candidate and others is that their manner of collection is in violation of Article 10 of the Election Code.
Thank you, counsel. So in looking at the objector's petition, it does look like there is a record examination is going to be required. Is that correct?
Yeah, that's correct. I
Okay.
think one of the things the board might want to consider before sending it to a records exam is the allegation with respect to the number of signatures required, because I don't, one, I don't agree with that number, and 2, I think we need to settle on what that number is before we determine whether or not the candidate is above or below that number.
And what does this one, what is the allegations?
The allegation is that the candidate is short of the 566 required.
Okay, just on its face.
No.
Oh, okay.
No.
No, but my comment is that I don't believe 566 is the correct number.
Understood.
Our contention is that that could be raised in a motion. I think we will need a records exam.
Yeah. And given that this is mayoral in the city of Aurora, and I'm just flipping through, I have a copy of the petitions, it looks like we'll need to use mainly Kane County, but also DuPage County
Will.
for the record examination. I don't see any other Will or Kendall, so that would help limit that. But knowing that we have to do that, we'll have to start coordinating with their clerk's office for their various procedures, and that I know that DuPage's will be different than Kane's.
And
So-
there are some will.
There are
signatures
some
in
will?
there.
Okay.
I believe there's 12.
Oh, yeah, I just saw one. So with three different electoral board, three different county clerks, excuse me, we'll need to start coordinating. So I would recommend a motion to order that this matter do proceed to a records examination with the issue being preserved of the arguments of the minimum number of signatures required for any legal briefings that we'll talk about in a second.
So moved.
Second.
Motion made by Alderman Mike Seville, second by Stelling. All in favor, say aye.
Aye.
Okay, motion passed.
Okay, so I will, as board's counsel, I will contact those election authorities, and as soon as we have information about how they want to proceed, I will provide that information to the parties as well as to the board members. Of course, the rules provide that the procedures that the county clerks use will generally be what the board adopts and has adopted as the procedures for the record exam in these matters. Any nuances or differences we'll just work out and come back together and put it all together, I guess. And if there are objections to the Will County, like, I'll try my best to go through, and if there are objections to Will County or DuPage, or if maybe some of those counties are just, there's signatures where they're not objected to type of thing. See how many are in each. There are, okay, good. And then, so we'll issue the directive, and the parties are advised to be aware that they likely need to be present at those records examinations. The rules require it. Some of the county clerks, my understanding is, don't necessarily allow it or like people to be there, and we would adjust those rules accordingly for the preservation of objections, but at the same time are highly encouraged to be there and to follow the rules of procedure as presented. Furthermore, there were other issues, I guess, legal issues raised. Is that correct?
That's correct.
Mr. Mullen, that's your understanding as well?
Yes.
Okay. Would you want to set would it be appropriate to set a briefing schedule and hearing and argument schedule on on those matters?
Yes, it would.
Yes.
What are you thinking? How much time? Would you want to file a motion, or just have Mr. Fogarty file a brief in support, or?
I'd ask for a motion.
Well, it's his allegation that there's a certain number that's a minimum. I think it's his obligation to prove that that's the number, regardless of whether there's a motion to dismiss. We will file a motion to dismiss on the legal claim. Yes.
Okay, so we'll do any preliminary motions and maybe like an opening brief. How much time do you guys need?
Tuesday?
Tuesday the 12th?
We're going to be in session Tuesday?
No. This is for them to file their first things, then they'll need time for a response, then a reply, and then we'll come back. Probably, I would presume, that week after next. Does that? So then, Tuesday, the 12th, for a opening argument, and or a preliminary motion. I guess response would be Thursday then, right?
That'd be fine.
So, and I haven't had a chance to review these. Served by email by 5 p.m.?
Yes, that's,
Fine.
yeah, all services by email. And please make sure to copy me as counsel for the board in those emails at elections@omfmlaw.com. And then any reply, if any should we say, do you want the weekend, or is Friday sufficient?
Friday's fine.
Same.
Okay. And then, board, when is best for you to come back that next week, starting at the 18th?
I got a new
Week of the
phone
18th.
yesterday,
Yeah.
and
How's that working?
calendar's not coming up.
Any
Oh,
part-
sorry.
How many
Sorry, a
hours?
second.
That one will probably be a little bit longer.
Like, what do you mean? Guesstimate.
I would say, but how long, not holding you to it, how long do you think per side would you require for arguments?
15 minutes.
Yeah. I would say for each case, I would give yourself at least a couple hours for the whole, because we'll probably have each of the cases come back that day.
2 hours for the whole day.
I hope so, yeah. Maybe more,
Maybe more.
a little bit more, yeah.
I can do the 18th at 8 a.m.
Me too.
Monday, the 18th at 8 a.m.?
At 8 a.m.?
Yeah.
It's fine here.
Okay.
All right.
Counsel, are we going to be assured that the records exam would be completed by that time? I mean, should we wait on this argument until it's all complete and do it all at once? It's
That,
obviously your
yeah.
call, but
This same argument was made in the 3 cases before you. I think, at least for the other candidates, getting this resolved is going to be important. So I would urge the board to hold the hearing on the 18th, regardless of where the records exam is, so that the issue as raised in the other objections is resolved for the ones that don't have a records exam.
Yeah.
no objection. Doesn't-
Yeah, I think that's fine, and we'll have a status on this record examination. If it's completed, you know, the rules provide for case management conferences without the full electoral board, so we can always set up a telephone conference if needed to just do a case management scheduling such. And if we're proceeding to a full evidentiary hearing on the 18th, I guess we can try to proceed with that, or we can set that schedule next week at some point, if that works for the parties. Does that work for the board? Right,
Yes.
Basically, what's been said, we don't know when the record exam for the review of the individual signatures with the various county clerks, when that's going to happen. And so, if it does happen within next week, then we can proceed with everything potentially on the 18th, any evidence and any legal arguments, et cetera. If not, we'll have to have another date and we'll schedule and coordinate accordingly.
For just this one or for all?
I think this is the only one that has that type of major evidentiary issue, I believe.
That's right.
It's fine.
Okay, so if everyone's in agreement, just to recap, we will be, or the board has ordered this matter go out to a record examination. Any opening briefs or any preliminary motions will be due Tuesday, November 12th at 5 p.m. Any responses will be due Thursday, 11/14 at 5 p.m. Any reply, if any, are due Friday, 11/15 at 5 p.m. And then Monday, hearing and arguments on any motions and the opening legal arguments be Monday, November 18th, 2024 at 8 a.m. here in City Council chambers. And that will also be for, at this point, status of the records examination and potential evidentiary hearing if those record examinations are completed in enough time to file your respective Rule 8 motions. Is that your understanding, or do you understand and agree to
Yes.
those?
Yes.
Okay, thank you. So at this point, then, I'd request a motion to enter the briefing hearing and argument schedule as previously stated.
So moved.
Second.
Second, okay, motion by Max Sebel, second Jennifer Sterling. All in favor, say aye.
Aye.
Motion pass.
Thank you. And then, so this particular case, I would ask for a motion to recess until November 18th, 2024 at 8 a.m.
So moved.
Second.
Okay, motion by Mike Sebel, second by Sterling. All in favor, say aye.
Aye.
Okay, motion pass.
Thank you. Second case. I'll make copies of this and scan it to you guys, if that's
Okay.
all right. Just makes it easier
Yeah.
instead of keep
Yeah.
passing them out. If you want copies of these, the unsigned ones, let me know. The next case will be case number 2. That's Tara Loza versus Karina Garcia. Case number 24AMOEB02, also with respect to the office of mayor of the city of Aurora. Counsel, can you please introduce yourself and acknowledge your appearance?
Good morning, John Fogarty on behalf of the objector.
Carrie Lynn Craftifer on behalf of Karina Garcia, who's also present here today. I do have an appearance for the board and for Mr. Fogarty. This time.
Thank you very much. And Ms. Krafthofer and Mr. Fogarty, if you can, after the hearing today, can you please email me your
I will.
appearance-
I will.
appearances, and email each other your appearances as well?
Yes, we will.
Great. So at this time, for this case, will also be, it's appropriate for the electoral board to enter its own exhibits, and I would request that these exhibits be moved into evidence as stated. They would be Exhibit 1, I propose to be the objector's petition. Exhibit 2 be the candidate's nomination papers. Exhibit 3 be the call of this electoral board. Exhibit 4 be the agenda for the initial hearing. Exhibit 5 are the proofs of service, waivers of service, and appearances filed by the parties. Exhibit 6 will be the rules of procedure previously adopted by this electoral board. And therefore, with that, can I please get a motion to accept the electoral board's exhibits into evidence as presented?
So moved.
Second.
Motion by Mike Seville, second Jennifer Stelling. All in favor, say aye.
Aye.
Motion passed.
Thank you. Objectors' counsel, can you please provide a brief summary of the issues raised, and if this case will require a records examination?
Surely. This case will not require a records exam. There are 3 main issues in this case. First, the candidate has failed to file a proper statement of economic interests as required by the election code. Second, the candidate is not either not registered properly at her address shown and/or has a ballot name issue as set forth in Article 10 and in the objection. And then thirdly, the manner of collection of the petition signatures supporting this candidate has run afoul of Article 10 of the election code.
Thank you. So these are all, it seems, legal, or will there be an evidentiary hearing? Will that be required?
These are all legal arguments.
Yes, Mr. Seckler, I have spoken with Mr. Fogarty, and we talked about entering into a stipulation regarding facts, and then I would file a motion and we would need a briefing schedule.
Perfect. That would be great if you can have agreed stipulations of fact. That would be extremely helpful, of course, if you don't mind filing that with the board before the next hearing date. And so I would propose that we adopt the same briefing schedule that was adopted in the prior case.
Could I possibly have it till Thursday at midnight to file a brief, just because we're in the process of convening 32 other electoral boards within the next week, and I also have a out-of-town conference Monday through Wednesday?
We have no objection to that.
Okay.
And we've spoken about this.
Okay. So on this case, you would want any opening brief or motion due on Thursday the 14th? And then then I guess,
If I may have Monday at midnight.
okay. So this one would not be going to, we'd have a different hearing date then, I guess.
We
I have a
would.
conflict with Monday morning, the 18th anyway, so I
Okay.
wouldn't be able to be at the same time.
Others. And for the reply, what kind of time for Tuesday then?
Yeah, 24
20.
hours would be fine.
And for this case, we'll need to pick a different date than the 18th, I guess. What other days that week work for you? This one is a purely legal argument, so it shouldn't theoretically take as any long. The other one, I wanted to give more time because if there was any fact evidence and evidentiary hearing, it would take a little bit longer.
And I have a question. What are our fiduciary responsibilities in terms of a time limit? What is our time limit that we have to come to a decision?
It'll be by mid-December, we really.
Mid-December.
Mid-December, but we want to move a lot faster than that.
Well, I realize that, but also please realize I have another job,
Yes, of
full-time,
course.
that I'm expected to work.
Yes, of course.
Okay. So give me that date again.
So if they're finishing their briefings at the midnight on or it'd be 11:59 on Tuesday the 19th. Then we could do either Wednesday the 20th or the 21st, or Friday the 22nd, whatever works for you, the board.
And what was the time frame that we need at this particular meeting, would you guesstimate?
Yeah, I'd say probably an hour of argument.
Yeah.
I could do it the 19th.
So our final brief will be due on the 19th, not till midnight.
Could we make it the 20th? I'm sorry. Sorry.
Yeah,
Wednesday?
Do Wednesday the
Wednesday the
20th.
20th.
Wednesday the
yeah.
20?
What time?
8 a.m. again.
Does that work for the parties?
Yes.
Okay, good. Okay. So just to recap, and to confirm with the parties and the board, this matter is purely legal. The parties will enter into stipulated facts and will produce any evidence necessary for the board's record will be produced prior to the next board's hearing. The parties have agreed to a briefing schedule where the opening brief and any motions would be due Thursday, November 14th at 11:59 p.m. Any response would be due Monday, November 18th at 11:59 p.m. Any reply, if any, would be Tuesday, November 19th at 11:59 p.m. And then the hearing in this case, which would be for the legal arguments, would be Wednesday, November 20th at 8 a.m. Do the parties agree to that?
Yes.
We do.
Thank you. And the board, is that?
Yes.
Okay.
Yes.
Therefore, I'd ask a motion to set the briefing and argument schedule as stated and summarized.
So moved.
Second.
Okay, motion by Mike Seville, second by Stelling. All in favor, say aye.
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 Motion passed.
So therefore, and then this case would be, I need a motion to recess this case until Wednesday, November 20th at 8 a.m.
So moved.
Second.
Okay, motion passed by Alderman Mike Seville, second Stelling Silver. All in favor, say aye.
Aye.
Okay.
Thank you.
Mr. Seckler, will the board be issuing a written order on that, or?
Yeah, I will endeavor to, as quickly as possible, issue case management orders that summarize the proceedings from today.
Thank you.
For all the cases.
Thank you.
Third case.
Okay. Next one.
Okay. Now we'll move on to the third case. This is Taraloza versus John Leish, case number 24-AMOEB-03. Can the parties please introduce yourself and enter your appearances?
Sure. John Fogarty on behalf of the objector.
Ed Mullen on behalf of the candidate.
Thank you. And have you both entered or tendered your appearances, or can you please make sure to email them to me and to the opposing counsel after today's hearing?
I will tender today.
Okay, thank you.
Yes.
Then At this time, we'll be introducing and labeling our electoral board exhibits as we have in the prior cases. I propose the following: that the Exhibit 1 be the objector's petition, Exhibit 2 be the candidate's nomination papers, Exhibit 3 be the call for the electoral board, Exhibit 4 be the agenda for the initial hearing, Exhibit 5 be proofs of service, waivers of service, and appearances filed by the parties, Exhibit 6 be the rules of procedure previously adopted by this electoral board. Can I please get a motion to accept the electoral board's exhibits into evidence as stated?
So moved.
Second.
Motion made by Alderman Mike Seville, second by Stelling. All in favor, say aye.
Aye.
Thank you. Those will be adopted and entered. In this case, can the objector please just briefly describe without argument the summary of the issues raised?
Yes. Similar to the prior two cases, the candidate here, his method of petition collection runs afoul of Article 10 of the Election Code, and in particular, in the manner it should be applied to nonpartisan candidates.
Thank you. Mr. Mullen? Okay. Does this require this does not require a record?
It does not.
Are there would there be any need for an evidentiary hearing, or if there's any facts that both can stipulate into evidence? Or?
I don't believe there would be an evidentiary hearing necessary.
Okay, thanks. So in this case, we'll just need to set, I assume, legal briefings and arguments? Is that?
Yes, I understand the board has adopted a rule that requires motions to be in writing. However, I would request that the board hear an oral motion to dismiss on this issue. Mr. Fogarty's objection is based on Section 10-4 of the Illinois Election Code, and his allegation is that that prohibits candidates and circulators from circulating for multiple nonpartisan candidates based on the statute that prohibits that for independent candidates. However, there's a First District Appellate Court opinion that explicitly says that dual circulation for independent candidates is allowed. And so the entire basis of the objection is overruled by the First District Appellate Court in a clear appellate court opinion that is on point. And I think that Mr. Fogarty, having filed this objection, should be prepared to argue this, and it's a fairly simple motion based on a single appellate court case.
For the purposes of today's proceedings, we really aren't entertaining, unless the board really wants to, entertaining full, extensive argument. And this would be, especially to have a full and complete record, if it is a simple motion, if you can just please put that motion into writing and actually and make the legal argument and citation so the board members can all understand and see that. Thank you.
And yeah, I would ask that be put in motion. I believe you're referring to the Wiseman case?
The McGuire case.
Oh, okay. Well, I'm sure it is very simple, and I'm sure I've read the case. However, if council would like to raise a motion, I ask that it be in writing so that it can be properly presented to all of you.
In council, Mr. Steckler, I would agree with that. I would like to see it in writing as well.
Thank you. And you won't be precluded from any arguments you want to make. Just please, I think it would be best and proper, especially for the record, to have that in writing. And that's what is required by the rules. So what is we have two competing briefing schedules, so whichever, I guess, you prefer at this point. If you want to do the same, what we did in the first case.
Yeah, and the first case will necessarily include these
Yeah.
same arguments, I would think, if council is going to remain council in that case.
Yeah.
So either schedule is fine with me.
Perfect. So that was Tuesday, the 12th. At 5 p.m. for any motion or opening briefs. Then it would be, I believe, Thursday the 14th at 5 p.m. for any responses. Then Friday the 15th at 5 p.m. for any reply. And the hearing on that one will be as well on the 18th, Monday, the 18th at 8 a.m.
Great.
Does that work?
Yes.
Okay, Okay, so to summarize, this case is purely legal, as described by the parties. The arguments, any opening briefs and any preliminary motions will be filed Tuesday, November 12th at 5 p.m. Responses will be due and filed Thursday, 11/14 at 5 p.m. Replies, if any, will be Friday, 11/15 at 5 p.m. Then the hearing at this case will be immediately after the first case on Monday, the 18th at 8 a.m. We'll hear all the arguments, and as stated in the prior case, I will endeavor to, as quickly as possible, issue a case management order reflecting that, assuming the board adopts the schedule, and we'll hear any and all arguments on this case on the 18th. If I can, please get a motion to adopt and approve that briefing and hearing schedule.
With the 2 hearings, what is the timeframe for that, more do you anticipate?
With the 2 hearings, it depends on the first case, how long that goes, if that needs to go longer. And we can always, I guess if we needed to, give that to a different day for evidentiary matters. But I assume, and for this case, an hour, 30 minutes? What do you?
30 minutes. I mean,
I don't think any of the arguments in this case are going to be different than
Right.
the arguments
Gotcha.
in the other case. I think
Right.
you could probably combine them into one with each of us 15 minutes.
Okay,
Okay, that's fine then.
okay, perfect.
So moved.
Second.
Motion by Alderman Mike Seville, second Alderman Stallings. All in favor, say aye.
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 Okay.
Motion passed.
And then thus I would need a motion to recess this case until Monday, the 18th, Monday, November 18th at 8 a.m.
So moved.
Second.
Okay, motion by Alderman Mike Seville, second Alderman Stelling, Jennifer Stelling. All in favor, say aye.
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 Okay, motion passed.
Thank you.
20.
thank you.
You're
Okay,
done.
perfect.
Thank you very much.
No problem. Now you wanna come to the other ones?
Do you have we got a different one.
Here's the file. Someone passed those. So for the next cases, these are about aldermanic candidates, and therefore the mayor is not just statutorily disqualified and must sit as the chair of the electoral board. As a preliminary matter, because this is technically a different makeup of the electoral board, we're going to run through the first part of the proceedings to call quorum, recall quorum, and readopt our rules of procedure. Mayor, if you'd like to.
All right, I'm Mayor Richard C. Irvin, the chairperson of the Electoral Board. Also on the board is Mike Seville, senior alderperson, and Jennifer Stallings, city clerk. The Illinois Election Code mandates our service to hear and pass upon objections filed against candidates' nomination papers in the city of Aurora. Now, at this time, I will ask the city clerk to please call the roll.
Mayor Irvin,
Present.
Alderman Seville,
Present.
and City Clerk Stallings present.
And substitute chair Garza is present as well, in case she needs to step in for any reason. All right, at this time, we are going to address the rules of procedure. I'm going to briefly turn it over to our board attorney to explain the proposed rules of procedure.
Thank you, Mr. Mayor. Again, this is Ross Seckler, the Electoral Board's attorney. The proposed rules of procedure that were adopted by the prior iteration of the board are generally from the Chicago Board of Election Commissioners, the Electoral Board, Cook County Officers Electoral Board, and a little from the State Officers Electoral Board, that are professional agencies that often hear these types of hearings. These board rules are also almost identical, substantially similar to prior iterations of these rules that this Aurora Electoral Board has used in years past, and therefore, they're provided for both the parties and the board to be able to have a clear precedent of how to manage and and deal with these proceedings and the deadlines and requirements of being part of them. And copies should be on the podiums for the public or for the parties to review. And therefore, I would request that the board adopt, or at this iteration of the board, adopt the rules of procedure as presented.
Is there a motion to adopt the rules of procedure presented?
So moved.
Second.
Moved by Mike Seville, seconded by Member Stallings. All in favor?
Aye.
Aye.
Those will be adopted. If you-
I move that this electoral board adopt the rules of procedures presented. We did that.
Yeah.
Attorney Seckler?
Perfect. So we'll continue on the case list. We'll start with the fourth case. This is, and I apologize if I mispronounced the first name, Salih Khalid versus Ariana Dalman, case number 24 AMOEB 04. Are the parties present or counsel? Can you please introduce yourselves?
Hello, good morning. My name is Salih Khalid. I am the objector.
Good morning, Ariana Dahlman, the respondent.
Thank you. Are you planning on representing yourselves, or are you going to engage counsel, either of you?
I plan to represent myself.
Okay, thank you.
I'm also representing myself unless anyone is offering to represent me. Then I think it's self.
Okay, thank you. If either of you do obtain counsel, just please have them contact me directly and enter their appearances. If you can, there should be appearance forms on the podiums. If you can please fill those out and provide, either you can just provide them to me and I will distribute them, or if you want to do 2 copies, you can give one to the your opposing side so you know how to contact each other. It's very important that you take a copy of the rules of procedure, which I will also provide to you by email afterwards, and please make sure I get a copy of your appearance so I know where to send those these rules and any notices to. Any filings will be by email, and please make sure that you copy your opponent on any filings or any emails to me on behalf of the board. And in the rules, it says explicitly where to send that, and then I'll send, like I said, I'll send you an email and probably a case management order that summarizes what we do today, with all the with any deadlines, et cetera, and you can just reply directly to that email address too. And so at this time, it'd be appropriate for the electoral board to enter its own exhibits into the record. I propose Exhibit 1 be the objector's petition, Exhibit 2 be the candidate's nomination papers, Exhibit 3 be the call of the electoral board, Exhibit 4 be the agenda for the initial hearing, Exhibit 5 be proofs of service, waivers of service, and appearances filed by the parties, Exhibit 6 be the rules of procedure adopted by this board. Can I please get a motion to accept the electoral board's exhibits into evidence?
So moved.
Second.
Been a motion made by Alderman Seville, second by Member Stallings. All in favor?
Aye.
Perfect. At this point, will the objector please just briefly, without argument as much as possible, just state what the issues raised in the objection are and whether records examination is required.
And the basis of my objection is that the candidate did not submit the minimum number of valid signatures needed for an alderman at-large candidate to appear on the ballot for various reasons that were outlined in my objector's petition. And yes, I do request that a records examination take place.
Okay, thank you. Is that your understanding as well, ma'am?
Yes.
Okay. In this case, just flipping through as well, because it is Alderman at large, we will need to coordinate between the 4 election authorities of the 4 different counties making up the city of Aurora. And so I will, assuming the board so orders, I will do that and coordinate, and we'll be in touch with the parties about what those specific record examination procedures are, where the county clerks will actually go and make preliminary determinations about whether these individual signature line objections are good or should be sustained, meaning the signature is bad, or if they should be overruled, meaning the signature is good. So I will coordinate that because each one will have its own different nuances and procedures, and I'll let the parties know what the status is of that, as well as let the electoral board know. Are there any other issues other than individual signature objections in this?
No, sir, no other issues.
Okay, thank you. So, do you plan, ma'am, do you plan on filing any sort of preliminary motion to strike or dismiss this case?
I might,
Okay.
yes.
And so, yeah, you obviously, you absolutely have that right to do that, and we'll set a briefing schedule. You do not have to, but if you would like, we can set a briefing schedule similar to what we've done in the prior cases. And for this one, why don't we do Alderman on, for the which day is better, than the 18th? I know before we get in, I want to know which.
I can't do any more than you
Okay.
Unfortunately, I'm not here on the 20th,
Okay.
and I want to work with Alderman Seville's schedule.
Yeah.
Is the 22nd available for you if we do it at 8 o'clock in the morning? This one shouldn't take long, this records review. Either there is or
I have a
isn't.
noon appointment that I have.
Oh, no, we'll be done. We'll be done.
Yeah, I can do it 8 o'clock, the 22nd,
Yes.
yes.
Are either of you available on 8 a.m. on the 22nd for hearing, and then we'll set briefing after
Can
that?
you remind me what day of the week that is?
Friday.
Friday?
Yeah,
I'll be here.
okay.
Yes, I'm available then.
Okay. And so there's a little time, but you'll also have the record exam. So I would propose that any initial motions be due, why don't we follow the second cases? Briefing, would any initial motions be due on Thursday, the 14th by 11:59 p.m.? Then Monday, the 18th, for any responses at 11:59 p.m. And then any reply would be due Tuesday, the 19th at 11:59 p.m. And just remember to read the rules about what's called a Rule 8 motion, a motion that you have to make after the records examination if you want to preserve the right to bring any evidence before the board in terms of the individual signature rulings. And if those need to change, because, for example, I think DuPage County does do some record examination things a little bit differently, I'm sure the board will accommodate accordingly, and we can always set up a case management telephone conference between the three of us before the next hearing date, and then I'll communicate that to the board. So just to recap, this will just be entered, and I will put this in a case management order, but this matter will be proceeding to records examination, and that is it, with the ability to file any preliminary motions, and the briefing schedule as follows. November 14th at 11:59 p.m. for any motion or opening brief, any response at November 18th at 11:59 p.m., any reply November 19th at 11:59 p.m., and then the hearing on any arguments on this case or any evidentiary hearing would be November 22nd, Friday, November 22nd at 8 a.m. Is that the understanding of the parties?
Yes.
Yes.
And the board, that works for the board? Okay. Can I get a motion to adopt that hearing and briefing schedule as well as the issuance of the record examination, approval to proceed to records examination, motion to do? as stated. and
So
summarized.
moved.
Second.
Motion made by Alderman Seville, second by Clerk Stallings. All in favor?
Aye.
Aye.
Great. So then we'll need a motion to recess this case until November 22nd at 8 a.m.
So moved.
Second.
Motion made by Alderman Seville, second by Clerk Stallings. All in favor?
Aye.
Aye.
Perfect.
Okay.
Motion
Thank you,
carries.
everyone.
Next call, the next case is Richard Better versus Jose Torres. We don't have to redo.
It's fine.
Good morning. Emmanuel Llamas on behalf of the petitioner Richard S. Better.
Good morning, Jose Torres, candidate.
Thank you both. Have you had a chance to enter your appearances, or will you?
I have not entered my appearance yet, but I will get that to you over later today.
Okay, perfect. And if you can, just email it to me, and if you have opposing, the candidate's contact or email, please always include him, of course, as well.
I'll get that after the fact.
Okay. And yeah, and please do that as well. And I have cards, or you can just email me your appearance as well. Do you
Okay.
plan on obtaining counsel?
At the moment, no.
Okay. If you do, just, of course, as I
Okay.
previously stated in the prior case, just have them
Notify
email
you.
an appearance to me and opposing counsel, and let me know.
Okay, no problem.
So at this point, for this case, it's also appropriate now to enter the electoral board's exhibits, as we have in the prior. Propose the following: the Exhibit 1 be the ejector's petition, Exhibit 2 be the candidate's nomination papers, Exhibit 3 be the call of the electoral board, Exhibit 4 be the agenda for the initial hearing, Exhibit 5 be the proofs of service, waivers of service, and appearances by the parties, Exhibit 6 be the rules of procedure adopted for this by the electoral board. Please give the motion to accept the electoral board's exhibits into evidence as presented.
So moved.
Second.
Motion made by Alderman Seville. Motion made by Alderman Seville, second by Clerk Stallings. All in favor?
Aye.
Aye.
Aye. Motion carries.
Thank you. In this case, objector, can you please, without argument, to the extent possible, summarize the issues raised, and if the record examination will be required?
Yes, the issue is that there are not enough valid signatures due to the signers not being registered at the address shown and other signatures not being genuine. So we would need a records examination.
Okay, thank you. In this case, it's my understanding that this is entirely within Kane County.
That's
Is that
correct.
Okay, so that makes it a little bit easier. Do you,
Can I ask a question?
yes,
So, it's the problem I have, right? First, they tell me that I need 35 signatures. And then once I get the signatures, then I have to retry because then they tell me I need 54 signatures. So then the second time around, I had 94 signatures. So is it 35 or 54? Because I'm confused.
so this is all legal argument that you'd have to make,
Mm.
and you'll have to assert.
Okay.
Either side will have to assert. And so what we'll do is, like we have in the prior cases, we'll set a briefing schedule, as well as ordering this to go out to the record examination, where the county clerk will review the individual objections to the individual line numbers, and make preliminary determinations, and you'll have the opportunity then afterwards to present evidence to overturn those rulings,
Okay.
as well as objector will have that right as well.
No problem.
And we'll also have briefings, a briefing schedule where if you contest the number of signatures required, then that's where that would be the most appropriate place to make that argument.
Okay.
And so at first, I'd request a motion to, by the board, to order that a records examination be conducted by the Kane County Clerk's office in this case.
So moved.
Second.
Motion made by Alderman Seville, second by Clerk Stallings. All in favor?
Aye.
Motion carries.
So that will be, I'll reach out to along with the other cases, reach out to the King County Clerk's office and be in touch with the parties about the procedures and dates, times, requirements for that, and if they allow people to be there in person, or how they conduct these types of examinations. Beyond that, I presume that candidate would want to file any preliminary motion in this case, and if you want to file any opening brief. Are there any other issues other than?
Those are the only
Okay.
issues.
If you do want to file an opening brief, you're welcome to, but I propose we stick to the schedule we just adopted for the prior one. So that would be any preliminary motion be due on the 14th at 11:59 p.m., that any responses be due at the 18th at 11:59 p.m. Any reply is the November 19th at 11:59 p.m. And then hearing be it Friday the 22nd on this at 8 a.m.
That works for me on the 22nd.
Does that?
Yes, that works for me too.
Would they go in order that day with the at-large challenger going
I
first?
believe, yes. If we can, if one's going to be very quick, we can try to get that one done first or something, we can kind of play with the schedule. Well, we set them for the same time so that we can do that. Just it depends on how they play out, and
Right.
some people may, things may change, so. So 18. So with that, does that work for the board? Same schedule
yes.
as the prior case? Okay. And the parties agree to that? That's a good schedule? Okay.
Yeah, okay.
Very
That works
good.
for me.
So I would ask for a motion to approve the briefing and argument schedule in this case, and set this case for hearing and arguments. The briefing schedule would be the November, first brief and opening briefs or motion would be due November 14th at 11:59 p.m. Responses due on November 18th at 11:59 p.m. Reply, if any, would be due November 19th at 11:59 p.m. And then hearing and arguments, as well as any evidentiary hearing, be set for the November 22nd at 8 a.m. Can I get a motion to approve that as stated?
So moved.
Second.
Motion made by Alderman Seville, seconded by Clerk Stallings. All in favor?
Aye.
Motion carries.
Perfect. So for this case, it would be appropriate now to recess this matter until November 22nd at 8 a.m.
Motion to recess.
So moved.
Second.
Motion made by Alderman Seville, seconded by Clerk Stallings. All in favor?
Aye.
Aye. Motion carries. This matter is recessed till November 2nd.
Thank you.
Thank you.
In our final case, this will be our final case for today is Brandon Tolliver versus Saul Foltz III. Case number 24 AMOEB 06. Are the parties or their counsel present? Okay, can you please introduce yourselves?
Brandon Tolliver, the objector, representing myself pro se. Saul Foltz, the responder.
Perfect. Do either of you plan to retain counsel, or are you going to proceed?
Not at this time.
Okay,
Don't proceed.
okay. If you can, please either fill out those appearance forms and provide a copy to your opponent as well as one to me. If you want to just fill out one, I'm happy to take it and I'll share it amongst you both, so you don't have to write it out multiple times. And like, as I've stated in the prior cases, I will issue a summary case management order following what we do today that summarizes everything, and then you'll have our email addresses as well. But if you can, so I can have your emails, please make sure I get those today. We have that at this time, like we did in the prior cases, we'll want to enter and label the electoral board's exhibits. And I propose the following: Exhibit 1 be the objector's petition, Exhibit 2 be the candidate's nomination papers, Exhibit 3 be the call of this electoral board, Exhibit 4 be the agenda for the initial hearing, Exhibit 5 be the proof of service, waivers of service, and appearances filed by the parties. Exhibit 6 be the rules of procedure adopted by this electoral board. Can I please get a motion to accept the electoral board's exhibits into evidence as stated?
So moved.
Second.
Motion made by Alderman Seville, seconded by Clerk Stallings. All in favor? Aye. Motion carries.
In this case, if the objector, can you please briefly describe without argument what the issues raised and if a record examination?
Yeah, absolutely. So, the matter before us today is a fairly simple one. Saul Foltz did not turn in the required amount of signatures to get on the ballot for the 2025 election for the Alderman of Ward 7 position.
Got it. It's just, so you allege on its face the petitions don't contain enough signatures? Is that
Correct.
Correct, okay. And to the candidate, do you contest that?
Yes, I do. I contest that as far as as the responder, due to the fact because I'm asking that this whole thing of the objector be thrown out on the grounds of that the objector himself, as filing the objections, did not turn in proper paperwork as far as to as according to the Illinois Board of Elections. 4610-8, saying that at one original and 2 copies, in which I messaged the clerk's office. I have everything in packet I give to the board. It states that only thing he turned in was 1 original and 1 copy. And I have it from the clerk's office stating all the documents that were turned in.
Thank you. So for this, as we have in the prior case, we want you to file a motion to strike or dismiss, and if you wanted to file any opening written arguments as well about if anything, or just respond, or you can just respond in writing. I would propose, as long as it works for the parties and still works for the board, to have this case follow the same briefing schedule that we had in the prior aldermanic cases, which would be your motion and any opening brief be due on November 14th at 11:59 p.m. Any response be due on November 18th at 11:59 p.m. And reply, if any, would be due on November 19th at 11:59 p.m. And then hearing and argument would be set for this case on Friday the 22nd, November 22nd at 8 a.m. Is that?
Mr. Zeckler, was actually the person who accepted Mr. Tolliver's objections, and it does seem that there is somewhat of a discrepancy. So I'm not sure how we would handle that, but we should probably address that.
Yeah, that would probably be. Yeah.
Okay.
So are you're making the allegation that
Yes, sir.
it would be
Yeah,
a
because-
factual issue?
Right, because under the rules and procedures to prevent someone from getting put on a ballot are hyper-technical and governed by Illinois statutes. According to Illinois statutes concerning objections to petition 10 Illinois CS 510-8 from Chapter 46, paragraph 10A, any objection must obtain an objector's petition toward together with 2 copies thereof. Objections, petitions that do not include 2 copies thereof shall not be accepted.
I guess what I'm saying is that,
And at that time, it was only
Hold
one
on,
original.
Mr. Foltz, just 1 second. Clerk Stallings?
Mr. Tolliver submitted an original and 2 copies.
From your office.
Well, hold on. So this is an argument that's
Yeah.
being made
Right.
right now. So the issue that Clerk Stallings brought up is the fact that she accepted the documentation that Mr. Foltz is disputing. Is she able to sit in judgment of this particular hearing? Is this one where we should have Alderman Garza step in on behalf of Clerk Stallings based on the fact that she is a potential witness?
Yes, yeah, I think that would be advisable,
Yeah.
given that if there's an issue of fact in this case that directly involves one of the members of the Electoral Board, there's case law that says we'd have to substitute out. So instead of doing that later, we might want to
Yeah.
just do that now.
I think is there an agreement that we do that now with the parties?
100%.
That we substitute out Clerk Stallings?
Right.
No objections.
And that Alderman Garza stand in her stead, so thank you. So at this particular time, Clerk Stallings has recused herself from this particular hearing, this potential conflict, and Alderman Garza will be a part of this particular hearing.
Yeah, and for the record, if you could, I think call roll of this electoral.
All right, for this particular electoral board, I am going to call the roll based on the conflict. Mike Seville,
Present.
Alderman Garza,
Present?
and I, Richard Irvin, am present. These will be the hearing These will be the folks that participate in this particular hearing.
Perfect. And that's because, and to note, we didn't do that initially. We didn't know that that was going to be a factual issue that came before us, but now it's before us, and we're just taking those proactive steps. So this will be the board hearing this final case number 6. If I could get a motion to readopt and reapprove, because this is a different iteration, the board, the rules of procedure as were presented and previously adopted.
So moved.
Second?
Motion made by Alderman Seville, second by Alderman Garza. All in favor?
Aye.
Aye. Motion carries.
If it,
Hold on one second.
On to this, yeah. As long as it still works for this board and the parties, we could still, still adopt the same argument and briefing schedule that the aldermanic cases have all followed so far, which would be, again, the motion, any preliminary motions or opening briefs would be due on the November 14th at 11:59 p.m. Any responses would be due November 18th at 11:59 p.m. Any reply would be due November 19th at 11:59 p.m. And any hearing and arguments would be on the Friday, November 22nd at 8 a.m. Excuse me, at 8 a.m. Does that work?
yes, it does.
Yes.
And it works for the board?
Does.
Okay,
Yes.
perfect. So I would ask for a motion to approve the briefing schedule and a briefing and argument schedule as summarized and stated.
So moved.
Second?
Motion made by Alderman Seville, second by Alderman Garza. All in favor?
Aye.
Motion carries.
And so with that, then this case we'll need a motion to recess this case until 11.
I believe Mr. Foltz had a question
Oh,
before.
yeah, oh, sorry.
Yes, I just wanted to say, as far as in the evidentiary stuff of that nature, what was said by Ms. Stallings, I have a copy of what I requested from her office on November 6th, and in response, the copies that are in question from her office. This is what I wrote to the city clerk of Aurora. I am writing to request.
Hold on, Ms. Foltz. I believe that's the argument that you're going to be
Okay,
making in
right.
the brief schedule we just set up. So you might
Okay,
want
all
to
right.
save that and put that in writing, and then you can make that argument on the date that was set for this hearing.
Okay,
Exactly.
just want proper transparency.
Yes. And so if you want, please provide any documents and evidence that you want to introduce, and also anything you submit to me on behalf of the board, please make sure you submit to the objector, as well as the same thing goes for you. If you're filing anything, please make sure it goes to me. Any documents or evidence, unless you want to agree to any sort of other time schedule, are due, I believe, 48 hours before the hearing at a minimum. Please make sure you take a copy of those rules, and I will also email out a copy of the rules today to you. If you can please make sure I get your appearances with the case management order. Please carefully review those rules. There are some strict deadlines, and because we have to move so fast, so make sure that you understand how you file documents with the board and what some of those deadlines are. Any other comments?
Nothing else to come before the board. Can I have a motion to adjourn?
Any other comments?
No. Any other comments from?
Any comments from the public?
Nope.
Motion to adjourn.
Second?
Motion made by Alderman Seville, second by Alderman Garza.
We have a motion to recess the Municipal Officers Electoral Board of the City of Aurora until the date stated.
All in favor?
Aye.
Aye.
Motion carries.
We stand in recess.
Thank you.